For hearing under order 41 rule item 34, second into 502 of 2017.
This is plaintiff's appeal. Plaintiff is issued title suit lawsuit. Title suit number 59 of 2002 for declaration of right and interest over the suit claim lawsuit, and also electing the different number 1, 2, 3 from the suit premises lawsuit. And further declaration, the said deed is suited by defendant number 3 lawsuit. If the said deed is suited by defendant number 2 lawsuit. In favor of defendant number 2 by Tara Devi lawsuit is null and void.
Tara Devi is defendant.
Tara Devi is defendant number 4. Defendant number 4.
So say it is executed.
Said it is by defendant number 4 Tara Devi in favor of defendant number 2 Indira Devi is null and void. Said it is executed 7 by 6 C.
What is the date?
Date is 14/10/1999. Said it number 3771 of 1999. 3771
1 of
1999.
19.
Dated 14/10/1999.
When was the suit filed?
The suit was instituted in the year 2002 and the London trial court dismissed my suit only on the ground of premeditation. And the London trial court not framed any suit, not given any finding. There is no issue framed by the London trial court. The case of the plaintiff is lawsuit. Earlier the plaintiff was partnership firm named as Miss Chatura and Hoyla.
Where is the trial court judgment?
Yes, trial court will be started. And this is paragraph 7 lawsuit. There is no suit framed by the London trial court.
No, because the proceeding was under order 8 Rule 10.
8 Rule 10.
Yes. So no issue is actually required to be.
As per order 8 Rule 10. This defendant not filed order 8 Rule 10.
Some
Procedure.
points for consideration has to be framed and will not specifically issued.
Yes, kindly come to paragraph 9 lawsuit of the trial court.
They framed and they posed a question to themselves and then they proceeded. The court proceeded thereafter. And from the date of saying the suit is barred by litigation. What was your cause of action?
My cause of action, paragraph 21 of my complaint, I did lawsuit. Right, the date of knowledge as per article 59 is the date of cause of action. That paragraph 19 of my complaint I have mentioned lawsuit. That the cause of action for the suit against the defendant arose to the plaintiff for the first time in mid-November 2002 when the plaintiff got a rumor in the locality with respect to sold of suit house and land was got knowledge of some illegal construction there, and then 18/11/2002 when the plaintiff obtained certified copy of the improved sale deed and
Who is
rectification
in
deed.
possession? Who is in possession?
As per the plaintiff lawsuit, the defendants are in possession of it.
So how do you say that the cause of action arose in only 2000?
Because the plaintiff were not aware about the
Not
Actually-
aware, you were already dispossessed. How do you say that you were not aware?
No, the case of the plaintiff is lawsuit. The original plaintiff lawsuit, namely Nandan Singh lawsuit, was employee of Miss plaintiff lawsuit. He was given a residential quarter lawsuit for the time when he completed his service lawsuit, and Nandan Singh retired in the
What
year.
happened before the first appellate court?
Yes, kindly see first appellate court.
First appellate court has not decided the case on litigation. The first appellate court has decided the case on merits, and the first appellate court has held that there is no authority
The first
or
update,
the person who has filed the case. A company is filing the case.
that,
There is no resolution of the board of directors.
Yes,
There is no authorization of the director to file the case. The court has said that the suit itself was not maintained.
that the two findings are contrary to each other.
No,
The
not
first trial court hold considered
No,
the
trial court you say that only dismiss the case on the point of limitation.
point of limitation.
That's
Now kindly see the first update court judgment law, see, page number 19 law, see. Paragraph 13 law, see, page number 19 law, see.
No, you forget about that. You first
No.
come to para number 10. Para 10 and 11.
Yes.
You are representing a company. Where is the authorization?
No, board of directors were there, law, see. Board of directors filed the suit law, see.
That is not correct. You read para 10 and 11.
In the statute also, no resolution was passed by the board of directors of the plaintiff company to authorize the director of the company to institute the suit. No such power who delegate to any of the directors of the company to appoint any person to institute suit on behalf of the company. Para 11, in view of the matter, it is quite clear that the so-called directors of the plaintiff company were not entitled to being a civil suit on any relief, as they were not empowered to file a suit on behalf of the plaintiff company. Hence, the point of determination is decided.
That's it.
No, kindly see
You
the.
first explain this. We'll see it later. You first explain this.
Yes, so for the
If the
first.
suit is not maintainable, the matter ends. No question of law.
So since the board of directors, since the all of the directors, say by the one
No,
of the
that is not the way in which the suit is filed on behalf of company. There has to be a resolution of board of directors to file a case on behalf of the company, and then the company is one of the directors will be authorized to represent the company and file the suit. You see, a company has 10 directors, right? One of the director goes and files the suit, and ultimately the director loses the case. Company would say, I am not bound by it because I never authorized him to file the case. He is not the managing director of the company.
as per the exhibit 4 notes, there is an order of registrar of companies. We have filed the article of association in memorandum.
It is immaterial.
To it, exhibit 2.
Merely because he is a director, that does not mean that he can file a case. In absence of resolution, writ नहीं फाइल होता है, writ नहीं फाइल होता उसके बिना. आप ये तो सूट का बात कर रहे हैं. Writ petition नहीं फाइल होता उसके.
The important fact is
That is the only important fact. You satisfy me on this. If this point is not decided, if any question of law is not framed on this point, rest is immaterial. You see, please appreciate. On the basis of this finding, the company can always say that this judgment is not binding on me because the director was not authorized to file a case. Company will still have a cause of action to file a case. आपको समझ नहीं आ रहा बात?
So when the first update court reconsider not the first update to holder, so apparently the execution of the same deed in question is binding law. So first update court.
It is not binding on the plaintiff company because the suit was not maintained.
Since the plaintiff approved the right law through hukumnama law. Earlier there was
We will not see how the plaintiff approved the title because the plaintiff is the company. And nobody, the person who presented the claim was not, his authorization was not placed before the court. In a case where the court is proceeding ex parte, these are the things which the court would definitely see before declaring the suit. Limitation, whether the suit has been properly presented, properly filed, whether the person is actually being represented.
Since no issue was framed on the trial court law.
Need not be.
Sir, Direct Trial Court ought to frame such type of issues also.
No, need not. Need not. These are the basic documents which you file before a court. In absence of those documents, how the suit will? And still you are not remediless. This is not binding on you. Is this binding? No. Essay number 502 of 2017. for the learned counsel appealing on behalf of the applicant. This appeal has been filed against the judgment dated 29/6/2017. Within bracket, the decree signed on 10/7/2017, passed by learned District Judge Roman II at Kodarma, entitled Appeal number 17 of 2015, whereby the first appeal filed by the plaintiff has been dismissed. The trial court judgment is dated 30/9/2015, within bracket, decree signed on 9/10/2015, bracket rules, passed by the civil judge within bracket senior division -1, bracket 2, civil judge within bracket senior division, bracket 1, Kodarma, entitled suit number 59 of 2002, whereby the suit has been dismissed under Order 8/10 of CPC. The learned counsel for the appellant, by assailing the improved judgments, has submitted that the plaintiff was a couple and the suit was filed for declaration of right, title and interest of the plaintiff over the suit land and for possession of the suit premises after evicting the defendant number 1 to 3, and also to declare that the SAD number 3771 dated 14/10/99 and connected rectification deed number 3777 of 1999 dated 15/10/1999 to be null and void and illegal, and also a decree for mandatory injunction directing the defendants to demolish the illegal construction made on some portion of the suit land and restrain them from making other constructions over the property, and also to restrain them from disturbing and changing the physical feature of the suit. The learned counsel has submitted that the cause of action for filing the suit arose against the defendant for the first time in mid-November 2002, when the plaintiff heard a rumor in the locality with respect to sale of the suit house and land and came to know about some illegal construction. And then the plaintiff on 18/11/2002 obtained the certified copy of the sale deed and the rectification deed. And lastly, on 15/12/2002, when the defendant number 123 refused to put and vacate the suit premises, ignoring the permissive possession of leave and license granted by the plaintiff company to its former Darban, namely Darban late Brij Nandan Singh. The learned counsel has submitted that upon due summon, defendant number 1 appeared and filed written statement. Defendant number 1 and 2 appeared and filed written statement. Defendant number 1 and 2 appeared but did not file. Defendant number 1 and 2 appeared and filed written statement but did not file the written statement within the stipulated time, and they were debarred from filing written statement. The suit was declared ex parte against defendant number 3. The name of defendant number 4, Tara Devi, was deleted by order dated 21/2006 due to her demise. The name of defendant number 5, Draupadi Devi, was also deleted due to her demise. He submits that the proceeding before the learned trial court was under order 8/10 of CPC, and no specific point, no specific issue as such was framed by the court. However, the court has dismissed the suit on the point of limitations. And also on account of non-joinder of necessary parties. The learned counsel has submitted that the first appellate court has dismissed the appeal without properly considering the materials on record. And has held that the suit itself was not legitimate. After hearing the learned counsel for the appellant, this court finds that the written statement filed by some of the defendants, as mentioned by the learned counsel for the appellant, were not taken on record, as the same was filed beyond the prescribed period. And so far as the two defendants concerned, their name was struck off on account of their death. With respect to one of the defendants, the proceeding was ex parte. The learned further appears from the record that the plaintiff adduced certain documentary evidences also produced as many as 6 witnesses. The defense of defendant number 1 and 2 was struck off, and they did not adduce any oral or documentary evidence. The learned trial court posed a question as to whether Sudhir Kumar Badani and Krishna Sharan Badani and Dayanand Badani were the directors of the plaintiff company, and whether they have the right to sue. The learned trial court further recorded that during the pendency of the suit, defendant number 4 expired, and a prayer was made to delete her name from the suit. The court recorded that it was essential to substitute her legal years after deleting her name, but the legal years were not substituted. Similarly, the name of Rocky Devi, who was defendant number 5, has been deleted on the prayer of the plaintiff, stating that the plaintiff does not claim any relief from the defendant number 5, Rocky Devi. It was also recorded that Rocky Devi is the daughter of late Odil Ram. The third daughter of Odil Ram was also not made party. The descendants of Chattu Ram were also not made party. Chattu Ram was the co-sharer of Khapa number 288. The learned trial court held that the suit was bad for non-jointer of his parties. The learned trial court further, on the basis of materials on record, was of the view that as per Exhibit 6, a case was filed under Section 87 of Tribunal Tenancy Act, being case number 1892/77, in which the Khata number 464, plot number 7509 and 7740 was corrected and mentioned in Khata number 290, and the court was of the view that this document of the this is a document of the plaintiff, and it shall be presumed that in the year 1977 the plaintiff company had full knowledge of the entry made in the Khatiyan published in the year 1976 with regard to Khata number 288, plot number 7568, 7569 in the name of Chattu Ram and Odil Ram. and recorded that the claim of the company that there was wrong entry in the record of rights was not substantiated by any documentary evidence. The learned court ultimately held that the suit was barred by litigation and also was bad for non-tender of the same practice. So far as the learned first appellate court is concerned, limitation का point नहीं बनाया था. No specific point was raised, was framed in connection with point of limitation. The learned first appellate court framed the following points for determination in page 14. The learned first appellate court by referring to the documents based on record has held that in the instant case, as held in paragraph 10 and 11, that no resolution was passed by the board of directors of the plaintiff company to authorize the directors of the company to institute the suit, nor such power to delegate to any of the directors of the company to appoint any person to institute the suit on behalf. And ultimately held that the so-called directors of the plaintiff's company were not entitled to bring a civil suit for any relief as they were not empowered to file a suit on behalf of the plaintiff. And held that the suit itself was not maintained. Paragraph 10 and 11 of the judgment passed by the learned first appellate court is quoted as under. So far as point of determination number 2 and 3 are concerned, they were taken up together by the learned first appellate court. And the first appellate court referred to the provisions of Section 84 of the Tobacco Tenancy Act and observed that there is a presumption regarding correctness as to final publication of record of right. And referred to the judgment passed by this court in reported in 1989 BBC 296 that every entry made in record of right is presumed to be correct unless such presumption is rebutted by strong evidence. The learned first appellate court also recorded that it was tough to believe that the plaintiff company had no knowledge about the alleged wrong entry in the record of rights in the revision survey of the 1967-68 name of two round and Koduri round in bracket joint and not in the name of plaintiff company. The learned court also recorded that the plaintiff had not filed any documents relating to imputation and held that the Mukurari Guami within bracket Exhibit 719 was executed prior to division record of right, and the same is related to the land of cadastral survey, and hence such registered document could not be taken as conclusive evidence to show that the suit land was acquired by a building company. The learned court also recorded that it was averred by the plaintiff that while indented within bracket registered family settlement dated 23/12/47 within bracket exhibit 7/B, specific share was given to the mother of the vendor on the sale deed in question, but observed that from the perusal of the sale deed transpired that there was no mention of any land in such family settlement, and only movable/liquid property were divided in the family, and share was also given to the mother of the vendor of the sale deed in question for her maintenance. The report also recorded that it was admitted fact that husband of the mother of the vendor of the sale deed in question, namely Horila, died in 1926, survived by his widow Madhu Devi, who was the mother of the vendor of the sale deed, and from the perusal of the sale deed and the challenge within bracket exhibit 7/C transpired that the suit land was sold by one of the daughters of Saint Madhu Devi to one Urmila Devi within bracket responsible too, with the reciting that after death of Horila, the vendor inherited the suit land as his legal heir, whereas evidence has been led by the plaintiff company to show that the vendor of the sale deed in question was married prior to commencement of Hindu succession at 1950. And also recorded that the sale deed was executed with particular copy containing a house, but the record of right revealed that the suit was jointly recorded in the name of Urmila and Chandra. The court also recorded that the undivided share of the company could be subject matter of transfer, but possession cannot be handed over to the vendor unless property is partitioned by means of bond, either by decree of the court in the partitions or by settlement among support shares, and the purchaser of this property having the right to seek partition and ask for it. The first appellate court recorded that the plaintiff company was not able to produce sufficient evidence before the trial to show that the suit land exclusively belonged to the plaintiff company, and also recorded that since upon for determination number 1 that the suit was not retained, no relief could be granted to the plaintiff company in the suit. During the course of arguments, the learned counsel for the appellant has not been able to satisfy this court as to how the findings recorded in paragraph 10 and 11 in the first appellate court's judgment as noted above calls for formation of any substantial question of law or suffers from any illegality or perversity. This court also finds that this court has gone through the improved judgment and is of the view that no substantial question of law arises for constitution
My only one submission
and
is-
according to
My only one submission is
dictation के बाद कोई submission
that the first appellate court ruled that the question is bad in law. The expression of the said in law.
Item 35, second 416,
Also,
Ms. Akila, who is there in this case?
Three appeals are there, Worship, 35, 36 and 37. One suit was preferred by us. In that suit, Lordship, that was declared in appeal. Thereafter, Lordship, 3 sets of defendants have preferred 3 sets of appeal. All the appeals have been heard. Since in 2 other
You are
appeals,
the plaintiff?
Lordship,
You are the plaintiff?
we are the plaintiff. 3 plaintiffs, now the 3 appeals by all the 3 plaintiff, respondent, appellants. The other 2 appeals, Lordship, have been preferred by my senior friend, Lordship, therefore he will be
There are,
established.
I think, in all the cases, Maheshwar Prasad Singh.
Yes,
is
he is the appellant, yes. We both
Plaintiffs
are
are the appellant in all the cases.
appellant in all the 3 cases.
So,
He will be starting. In 36, Lordship, he will be starting. Since the case is same, Lordship, everything is same.
it is arising out of the same suit.
Same, sir. And surprisingly, all the appeals of the state, of the my Dotiyas, and the third person, Lordship, Masonic Lodge, all has been heard. That he will be mentioned.
Okay. What was the suit for? And why was the state a party?
The state actually is also
Is also?
claiming the property.
State is also
Okay.
claiming the
Yes, the state is claiming that vested in the government. That appeal has also been heard. So,
What was the suit for?
suit was for declaration of title and for confirmation of possession. And for certain portion, it was for recovery of possession. And later on, the prayer was changed for the entire portion, the recovery of the prayer for recovery of possession was prayed. Our case was achieved that one Raja Shiv Prasad Singh,
इसका appellate court's judgment कौन है?
so, सब
इसका appellate court's judgment? इंग्लिश में है ना? ट्रायल कोर्ट हिंदी में?
जी।
नहीं फाइल किए क्या इसने?
नहीं, कौन सा appeal है? 448.
हाँ
448. नहीं,
करेक्शन के लिए क्या था मुझे?
पेज 27 हमारा फाइल में तो है।
बताइए। नहीं है। ये बात है।
पेज 26 बताओ 448 का एडमिट कोड जजमेंट नहीं है। पेज 26 देखा जाए
Page 26.
यस रनिंग पेज 27 जजमेंट उसका
हमारा तो जजमेंट ही 70 से शुरू होता है 70 ट्रायल कोर्ट
I'm giving the page. Page 124.
आपके वाले में
हाँ
उसमें
एक उसका उसमें
आपके रिकॉर्ड में नहीं है। कोई बात नहीं, सेम जज।
नहीं, अपील के नंबर पे अलग है उससे।
और तीनों अपील करना है।
अपील का नंबर अलग होगा ही, क्योंकि
हाँ
तीन अपील से आपने फाइल किया है इसीलिए।
हाँ
एक रिकॉर्ड से दूसरे रिकॉर्ड में पढ़ना मुश्किल है। आपका जो अपील है
जी
वो कौन से वाले अपील से है? स्टेट का अपील है कि कौन सा?
स्टेट का अपील जो है वो सिविल अपील 13 of 13
आपका केस सिविल अपील 13 से राइज करना है।
13 of 13 दो अपील हमने फाइल किया, एक सिविल अपील 13 of 13 से और दूसरा
बासठ
2
हमारा 59।
So the property has been declared in favor of the state.
No, property has been declared in the favor of Masonic lodge, for which he has preferred. They have filed a counter claim
तो
also.
स्टेट के खिलाफ भी आप अपील में क्यों आए?
इसलिए कि अपील उन्होंने भी अपील किया।
State
There are 3 degrees.
Just a minute. State is claiming the property.
Claiming
Masonic lodge is also claiming the property.
yes,
The property has been declared in favor of Masonic lodge.
Masonic lodge.
Then the state का अपील कैसे allow?
That is what I am saying. And not
And
only
a third person also.
and not only that, the third appeal for which I have preferred an appeal, some descendants of another sons of Raja Lakshmi Prasad Singh, they also intervened and said, it cannot be an exclusive property of Raja Kali Prasad Singh. It should be along with us. That appeal has also been done.
That is the third appeal.
That is the third appeal.
तो फिर आपने ये स्टेट तो फिर हार गया ना। अगर मान लीजिए स्टेट का टाइटल नहीं डिक्लेयर हुआ,
हमारे केस में जो टाइटल सूट में हुआ था उसमें नहीं, उसमें हमारे फेवर में डिग्री हुई, उसमें हमारा फेवर में डिग्री हो गया। उसके खिलाफ स्टेट ने भी अपील किया, मैसोनिक लॉज ने भी किया और जो राजा प्रसाद सिंह के दूसरे लड़के थे वारिसान से उन्होंने भी किया। वो तीनों अपील अलाउ कर दिए हैं।
तो तीनों का टाइटल डिक्लेयर हो।
हम तो यही समझते हैं, हमें तो नहीं समझ में आया कि ये कैसे हो सकता है। कम से कम क्लेरिफाई तो करते। अच्छा, ये इसमें मैसोनिक लॉज का जो काउंटर क्लेम भी, उन्होंने उनका काउंटर क्लेम भी अलाउ, काउंटर क्लेम अगर अलाउ किए हैं मैसोनिक लॉज का, तो माना जाएगा कि ये प्रॉपर्टी इन्होंने मैसोनिक लॉज को दिया। तो कम से कम दो तो अपील में क्लेरिफाई तो करते कि हाँ आपका कुछ नहीं होगा, जो है सो मैसोनिक लॉज का। ये भी ये सीरियस इलीगलिटी, ये पॉइंट हमने करेक्ट किया। तीनों अपील कैसे अलाउ आप करते हैं? और ये अपार्ट फ्रॉम दैट जो
मैसोनिक लॉज को आपने पार्टी नहीं करनी।
Masonic lodge was not a party, but he was being represented through TS Ghosh. वो पार्टी थे यार, उससे पहले जो उनका जो मैनेजर थे, पहले यार गुप्ता थे।
Masonic lodge was not a party.
Not.
Then how he can be represented through somebody?
वो तो ऐसे ही था, लेकिन नहीं बनाए थे। ये शुरू में एक्चुअल में हुजूर ऐसा हुआ है कि ये इनका जो केस है और ये हम लोग का भी केस है, ये 1919 द डिप्टी कमिश्नर टी लूबी रिक्वेस्टेड राजा शिव प्रसाद सिंह टू गिव सम पीस ऑफ लैंड फॉर मैसोनिक एक्टिविटीज। उन्होंने एग्री करके सॉर्ट ऑफ जब नॉट क्रिएटिंग एनी राइट, एक परमिशन के तौर पर उन्होंने उसको दिया। एंड लॉज भी बनवा के दिए, दैट व्हाट इज आवर बाउंड्री भी करवा के। 1944-45 में दे एवरीबॉडी लेफ्ट, देन इट केम इन आवर पोजीशन। और 1989 में ये प्रॉपर्टी जो हमारे केयर टेकर से गवर्नमेंट ने ली। और हमारा ऐसा केस है कि एयर टेकर से ले लिया। उसके बाद इन्होंने इसको अनक्लेम्ड प्रॉपर्टी के तौर पर एक एडवर्टीजमेंट दिया। तो हमारे जो केयर टेकर थे उन्होंने भी हमें इन्फॉर्म नहीं किया था। तो जब ये केयर टेकर के रूप में ये प्रॉपर्टी जब इसका इन्होंने एडवर्टीजमेंट निकाला तो इसमें मैसोनिक लॉज के AR गुप्ता ने इसे क्लेम किया और उसको अलाउ कर दिया डिप्टी कमिश्नर। उस ऑर्डर के खिलाफ हम हाईकोर्ट आए। हाईकोर्ट ने कहा कि नहीं, इसमें इश्यू ऑफ टाइटल वगैरह इन्वॉल्व है, इसमें आपको सूट में जाना चाहिए। तो इसके अलावा उसका रेंट असेसमेंट के लिए भी केस शुरू हुआ। रेंट असेसमेंट भी इन्होंने कर दिया मैसोनिक लॉज के नाम से। बाद में जो एक बार इनका पोजीशन ले लिया गवर्नमेंट से मैसोनिक लॉज, उसके खिलाफ वो चले आए हाईकोर्ट।
आप टैक्स कैसे क्लेम?
हमारा तो अपना
व्हाट इज द सोर्स ऑफ इट?
इट इज माय लैंड, खतियान में मेरा है, वकास मालिक लैंड, आई एम द राजा।
तो आपका जमींदारी में बेस्ट नहीं किया?
हमारा कहना है कि नहीं बेस्ट किया।
क्यों?
इसलिए
आप रिटर्न फाइल किया?
रिटर्न तो नहीं फाइल हुआ है पूरा, लेकिन बहुत सा जो कॉम्पनसेशन सीट्स वगैरह मिला है उसमें इन्होंने हमें बार सोपॉज किया है। वो सब डॉक्यूमेंट हम अपना रजिस्टर लाए हैं और हमारा कहना था कि ये एक होम स्ट्रीट लैंड है।
सब एग्जिबिट हुआ है?
ये सब एग्जिबिट, ये भी एक इशू इन्होंने उठाया था कि ये गवर्नमेंट का कहना है कि इट हैज वेस्टेड इन द गवर्नमेंट। तो उसके बाद भी इन्होंने स्टेट का भी अपील अलाउ कर दिया, मैसोनिक लॉज का भी काउंटर क्लेम भी अलाउ कर दिया और इन्होंने एक तरीके से मैसोनिक लॉज का पोजीशन 1919 से लगातार माना। दैट इज आल्सो वन पॉइंट ऑफ लॉ विच हमने फ्रेम किया। इसके अलावा मेन जो कि इनका क्लेम है कि ये राजा ने इन्हें गिफ्ट डीड से दिया, वो भी 1919। कोई भी डॉक्यूमेंट नहीं लाए हैं देर आर। और एक सिर्फ हमने एक एग्जिबिट 6 लाया था जो कि एक सादा पन्ना है, एक प्लेन पेपर है जिस पर कि क्यू लूबी साहब ने राजा साहब को लिखा था। वो वाला डॉक्यूमेंट को एक तरीके से अनरजिस्टर्ड फैक्टम ऑफ गिफ्ट मानते हुए उनका गिफ्ट का जो इनका क्लेम है उसको मानते। ऐसे भी 123 ट्रांसफर ऑफ प्रॉपर्टी एक्ट में गिफ्ट तो बिना रजिस्टर्ड डॉक्यूमेंट के तो हो ही नहीं सकता। दैट इज आल्सो वन ऑफ द पॉइंट ऑफ लॉ व्हिच आई हैव रेड। योर वर्शिप में काइंडली सी दिस सब्सटेंशियल क्वेश्चन।
The appellate court has said that it was bad for non-lawyer offenses. The suit was bad for non-lawyer offenses.
ये पॉइंट इन्होंने भी एक उठाया है, लेकिन हमने उसका भी वो भी पॉइंट हमने फ्रेम किया है कि whether the finding of the appellate court that suit is bad for non-joinder of necessary party is sustainable. ये भी पॉइंट हमने
किस पार्टी को बोला था necessary party?
मैसोनिक लॉज पे कह रहे हैं कि वो आपने नहीं बनाया, लेकिन मैसोनिक लॉज का रिप्रेजेंटेशन जो कर रहे थे देवेल पार्टी। preferred appeal, preferred writ petition, everything they have done.
So did he claim himself to be the manager of Masonic Lodge? Did he claim himself to be the manager of Masonic Lodge?
Yes. They are claiming that the property was being managed by them. Initially it was Air Das Gupta.
What is this? Masonic Lodge is what?
Masonic Lodge.
It's a company.
No. Masonic Lodge is a sort of a society which was formulated by Europeans for their some Masonic activities, spiritual and other activities. So they have also said that
Masonic Lodge, when they are formulated a particular thing about for spiritual and other activities, and after the British left
yes.
India, then how will it be retained by the manager? And how can a manager represent Masonic Lodge?
That what is their claim? That is what is their claim. That actually it was being they were always in possession, and every time they were in possession, so
Any adverse possession has been claimed.
No.
Masonic Lodge, there is nobody to claim as Masonic Lodge.
Masonic Lodge, name of the Masonic Lodge was entered in records of rights also.
But who will represent Masonic Lodge?
Masonic name.
Because they ceased to exist. Once
No,
they left.
as per them, it never ceased. It remained in existence.
How?
That what is their claim?
It is just a group of persons because it is an unregistered society.
That is what they are claiming. And the learned trial court has not believed it, dismissed.
Which are the substantial question of law?
First substantial question of law.
और सारा हम पढ़ने लग गए। देखिए जो फैक्ट पर है ना उसको छोड़ दीजिए।
हाँ।
आप सीधे सब्सटेंशियल क्वेश्चन ऑफ लॉ पे
हमारा-
ठीक से अच्छे से फ्रेम कराइएगा, नहीं तो सब गड़बड़ हो जाएगा।
हाँ। पहला तो एक डी देखा जाए, पेज 18, whether the learned appellate court by passing issued judgment and decree committed serious error of law in accepting factum of unregistered gift deed dated 2/4/2019 propounded by defendant number 6 to 8 for claiming suit property which was never brought on record.
ये तो आपका नहीं है, 448 बहस कर रहे हैं।
हाँ हाँ,
एक ही तीनों का एक ही
सेम ग्राउंड बना है।
ये वाला
हमारे में तो चूंकि some other counsel was there, substantial question.
Copy-paste।
Therefore, Lordship, I have given inquiry. Since मेरे में है ही नहीं ground.
क्या
This
है?
is the ground, Lordship.
कौन सा है?
वो ये इसलिए दिखाया जाता है।
पेज 17।
नहीं नहीं, तो इसमें आ जाना।
448.
448.
448।
हाँ, पेज 17।
पेज नंबर 80.
80.
18। ये तो आपने छोड़ दिया लगता है।
D.
D।
Whether the learned appellate court by passing impugned judgment and decree committed serious error of law in accepting the factum of an unregistered gift deed dated 2/4/2019 propounded by defendant number 6 to 8 for claiming suit property which was never brought on
और उसके
record.
अलावा
एक ये है, दूसरा जो इसमें लिमिटेशन के पॉइंट पर कोर्ट का कहना है, appellate कोर्ट का, कि 58 के से टाइम बार्ड, जबकि ये टाइम बार्ड इसलिए नहीं होगा क्योंकि रिकवरी ऑफ पोजीशन का भी हम लोग इसमें
Your Lordship, let me answer the question.
sorry
Your Lordship, I am appealing for defendant number 6 to 8. That
now
is the baseline.
we are at the stage of framing substantial question of law. You are not required.
So on the question of Your Lordship, the legal existence of missing clause which Your Lordship was asking, so that is there at page 27 of the judgment, that it was constituted as a trust and it continued its legal existence. So that answer is there,
We
which
will
the
see
learned
that.
counsel should have
We will
pointed
see
out.
that. We will see that. What trust? Who is the trustee? Who are the persons who are the trustee after the British left?
Yes, Your Lordship, at page 27 of the judgment, if Your Lordship will
Who
look
are
at.
the trustees? Give me the name of one trustee.
Yes,
Who
Your
is the
Lordship, Mr. T. Ghosh, who is one of the defendants, is
No,
a
no,
trustee.
he is a manager. He is not the trustee. Any document regarding his trust placed on
Yes,
record? Any
Yes,
document
yes.
to show that he is a trustee placed on record?
Your Lordship, I will produce the document on the next day, Your Lordship, it is part of the record.
No, we'll see that. We'll call for the record. We'll decide it. It's an intricate question. It requires admission and decision. Otherwise, also it's a judgment of reversal.
Yes.
Let's see what else.
Next is
E.
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 Whether the appellate court by passing impugned judgment and decree committed serious error of law in holding that the suit is barred by law of limitation it will be governed by Article 58 of the Limitation Act without examining that the relief of recovery of possession of Schedule B property was paid at the time of institution of suit itself and subsequently prayer for recovery of entire suit property was made by amending the relief.
This amendment would relate back
To original.
because you were dispossessed during the pendency of the suit.
From the part of the law.
Part of it.
So far as the Schedule B was concerned, it was already prayer for recovery.
What else?
Yes. Yes, ma'am. C also is relevant whether the learned appellate court committed serious error of law in considering a document Exhibit D series, Exhibit D series, Exhibit H, G, H series brought on defendant for recording a finding that Masonic cloth was throughout in possession since 1919 after the landlord of Jharia estate had given land to 15 UB which even has not been pleaded and same is nothing but one. It is not in this.
Serious error of law in considering the documents. How would this is a question of
That was without pleading.
That was without pleading.
It was without pleading?
Yes.
Has not been pleaded.
That should be sufficient.
Yes.
One more important
C, D,
2.4 is important.
CD.
That's
C, D, E and G should be sufficient.
C, D,
E and D.
E.
C, D, E and G should be sufficient.
One last one, my lord, is relevant for the
For
supervised
all the
present
three
appeal
appeals,
is concerned.
Aye.
That whether appellate court committed serious error of law, that is I, while passing improved judgment and degree allowing title appeal. 13 of 13, title appeal 16 of 12, title appeal 59, prepared by defendant number 1 to 5 state, defendant 6 to 8, and defendant 11 to 13 respectively, against the judgment dated 17th May 2012 and degree. The same is contradictory and legally unsustainable. How the three appeals can be allowed?
That's all. So it would be C, D, what else?
E and I.
C, D, E,
E.
G. G also.
C, D,
C, D,
E and I.
G, you are forgetting G.
Yes, Lordship. C, D, E and I.
G, you are forgetting.
G, G, H, A. Yes, Lordship. G. Obliged. Non-joined.
Mr. Ranjan, it is required to be heard. Did you hear it? When do you want to
Your Lordship, my only submission is that firstly, Your Lordship, it is barred by limitation itself because the DC order was passed in 1983.
We'll see that.
And
We'll see that. We'll see that. We'll hear
Your
that.
Lordship, if it can be heard at an early date, Your Lordship, because our entire rights are.
Choose your date. When do you want to do it? Choose your date. When do you want to do it?
Your Lordship, as early as possible.
As early. Okay, we'll call for the records at your cost and we'll decide the case at the earliest.
Any date in November, Your Lordship.
Okay. Done. All the records will come. Submit same. Submit same. For the learned counsels appearing on behalf of the parties. The counsel for the respondent will join the proceedings on hearing. The learned counsel for the appellant has submitted that the suit was decreed and 3 defendants filed separate appeals. 3 separate appeals. And consequently, and ultimately, each of the 3 appeals were allowed.
Including counterclaim.
One counterclaim was also allowed.
6 to 8.
Sorry?
6 to 8. Defendant 6 to 8.
Of
Which
defendant number
was
16.
filed by defendant number 6 to 8. The learned counsel has submitted that the decree passed by the learned first appellate court, when the judgment in each of the appeal is taken into consideration, is absolutely self-funded. As each of the defendants who filed appeal were claiming title over the property, and all the civil appeals were allowed. The learned counsel has also submitted that once British left India, there was nobody to represent Masonic Lodge. यही आपका कहना?
Their stand is that it was being represented.
But you are submitting.
I am submitting that
They had left altogether, Lordship, nothing was there except the building, and we entered into the building, that is our case.
There was nobody to represent Masonic Lodge as they had left India completely, leaving behind the structure of the lodge.
And it was under the caretaker of the plaintiff. We appointed a caretaker, he was there inside the premises.
All these factual questions are
Just a submission we are recording. We are not recording anything more. We are just recording what they want to indicate. The learned counsel has submitted that the plaintiff remained in possession of the property.
through his caretaker.
Sorry?
Through his caretaker.
Through?
His
Caretaker. Caretaker.
Who appointed it?
The landlord.
Who was the caretaker appointed by the landlord? After hearing the learned counsel, these appeals are admitted for hearing on following substantive questions of law. C, सब में C D सेम है ना?
इसमें दोनों में से
आपका सेम है?
Same.
C D E G and I.
सब में से
सब
सबसे वाला से इसमें 48 का ही
अगर यही सब फ्रेम कर देते हैं तो सब में कॉमन फ्रेम हो जाएगा
सब
ना?
में कॉमन सी डी सबका अलग इसका
अलग होगा लेकिन इसमें से लेना है
ठीक
ये ऐसे 448 का फ्रेम। At this, the learned counsel for the whom are you representing? Respondent number.
Your Worship, defendants number 6 to 8 in the suit, Your Worship, and in
All the
this
defendants.
DN Ghosh, Your Worship.
The appellate lordship of second appeal number 416.
Appellant of
The appellate of civil appeal number.
you are representing only T.N. Ghosh.
Yes.
Yes, Your Worship. Appellate of
59.
civil appeal 59 of 2012, Your Worship.
That is in second appeal lordship 314.
314.
416.
416.
448
Okay.
we
Just a
respondent number 6
So we are respondent number 1 in second appeal 416.
T.N. Ghosh and others. Who are T.N. Ghosh and others?
Lordship may kindly see my memo. 416 का memo देखें at page 2.
Yes, he is representing whom?
T.N. Ghosh.
Yes. And? Only T.N. Ghosh. You are representing only T.N. Ghosh. Have you entered? Have you filed wakalatnama?
Yes, we have filed a
On whom? On behalf of whom? T.N. Ghosh.
Yes, Your Worship.
others whether the party is same 6 to 8 where they defendant for other they may not
The Mr. Arvind Raj has already entered appearance by filing wakalatnama in all these cases on behalf of T and Ghosh, who was defending number
On behalf of defendant number 6 to 8, Your Worship.
6 to 8, 7 and 8 कौन?
Your Worship, Halda Prasad Chaubey and
He has already expired.
they have some
I just stated.
This is not correct. Haldar Prasad has already expired.
other person because his wife is
You are not aware whom are you representing. उनका वकालतनामा लिख रहे हैं.
Yes, sir. See, DN Ghosh, Your Lordship, 7 was BK Sinha, 8 is Haldar Prasad Chaubey. I'm representing all three.
Haldar Prasad Chaubey has already expired. कहाँ है इनका वकालतनामा? ये काउंसिल को खुद ही नहीं पता है किसको मिलेगा.
We had filed an IDA for allowing the Wakalatnama to be brought on record, which was allowed, Your Lordship, which is there in the earlier order.
Only TN Ghosh का वकालतनामा. Only TN Ghosh. और भी है क्या? नहीं. It's only TN Ghosh. He is representing only TN Ghosh.
Yes.
Therefore, no notice need be issued to respondent TN Ghosh. Issue notice to the other respondents.
We have given copies to state council.
आप स्टेट को भी नोटिस करें.
जी.
Issue notice to the other respondents. State of Bihar नहीं, not required.
Now state of Jharkhand is
हमने लिखा था तो it chief secretary.
Except the authorities of the state, except state of Jharkhand and the authorities under the state of Jharkhand. You will accept notice.
Serial number 37.
37.
Third case, 3 cases.
all three are
सभी में आप पार्टी होंगे भाई.
सब में.
The learned नाम बताइए अपना.
Krishna Kumar Bhatt, AC to AC.
Krishna Kumar
Third, AC to AC.
accepts notice on behalf of the respondent state of Jharkhand and its authorities. So no notice should be issued.
Other respondents are also part.
Sorry. हाँ वही है the authorities. Issue notice to the other respondents for which requisites under speed post. In each case, be filed within a period of 1 week. और तो कोई आईडी पेंडिंग नहीं.
All for the grant के लिए state grant.
Call for the records from the concerned court upon deposit of special miscellaneous cost by the applicant. तीनों में आपको जमा करना पड़ेगा. तीनों में जमा करना है. Appellate court का record अलग-अलग.
हाँ.
ठीक है. Since the proceedings are arising out of same trial court judgment, one set of trial court judgment will be sufficient. Right? For special messenger cost, we also some deposited within 1 week. सारे केसेस में जमा कर दीजिए. अब कब करना है? हाँ बताइए मिस्टर राजेंद्र राज, आपको कब करना है?
Your Lordship, first half of November, if it is possible.
करेंगे आप?
15 के बाद.
15 के बाद.
15 के बाद.
मुहूर्त निकालते हैं. Interesting है. It will take time, but
Yes.
Post for final disposal on 24th November. Parties to prepare short synopsis of arguments and list of judgments. This is to rely upon. Date is by 21st of November. Soft copy भी provide करेंगे. आप अपना बना लीजिए synopsis सारा का.
Yes, sir.
ठीक है. और soft copy भी provide करेंगे हमारे को.
Item 38, second appeal 463 of 2018.
May it please your lordship. Plaintiff is the appellant before your lordship.
Yes?
When a case was filed for declaration of right, title and interest over the property in question and for recovery of possession. Case of the plaintiff in short is that Hanju Kumari was the recorded tenant and we are the successors of Hanju Kumari. According to the plaint, my lord,
Plaintiffs are the successors.
we are the successors. Hanju Kumari died leaving behind one daughter,
No,
Helumani
that's okay.
Mari.
You were against Indian Iron and Steel Company.
What
What
happened?
was their case?
What happened, my lord? My father, in fact, the plaintiff, who is now dead, we are the sons of the plaintiff. The plaintiff executed two sale deeds, 6 acres each, to Indian Iron and Steel Company through its representative. There is no dispute about it. So they were given possession
6
about
acres each.
each. So altogether
12 acres.
12 acres. The entire
Registered.
in plot number 621, Hatiyan number 30.
621.
Hatiyan number 30.
Number 30. What is the date of sale?
Just date of the sale deed is registered sale deed number 8103 and 8104, both dated 1/6/1964. At para 3 of the grant, it is
So you
stated-
are not claiming 12 acres.
G. And the total area of Hanju Kumari in the said plot number 621, the plot only contains this much, 29 acres 16 decimal. This is the total area of plot number 621. It belonged to Hanju Kumari, who was the recorded tenant. These are admitted facts. Now, my lord, these two sale deeds were executed by Ram Singh, that is the original plaintiff. And Indian Iron and Steel Company came in possession, constructed quarters for the staff and officers of the Indian Iron and Steel Company
On this property.
on this property. Also, other properties they have also had. Later on, this a new project named Chasnala Koleri also came, which was included here. But that is not a matter of contention here. That is between ISCO Milon and then later on it became BCCL. That is matter of different matter. Now, subsequently, what happened in 2008 January, some portion was forcibly taken possession of. Initially 5 acres of land by
Which was over and above 12 acres.
G, over and above 12 acres.
How much was taken? And what was the suit property?
Suit property
Was about how much area?
17 acres 16 decimal. 12 acres we had sold and we were
17 acres,
16 decimal.
1/6.
1/6.
1/6.
We are doing agriculture over this in the major portion paddy agriculture, and we were growing paddy, and in the other higher lands we were growing makai and margua and
That's it.
some other.
What was the case of the defendant?
Defendant said that initially they said that Khanju Kumari had surrendered this property way back in 1950s. Then how come they purchased this property in 1964? Then they changed their stand and kept on continuously changing their stand. They said that it was surrendered. There is no date of surrender. Surrender can be oral even, but there is no date of surrender. Now they say it was settled with some some ojha. Now those ojhas also do not have any document of settlement. So these are the facts brought by written statement.
They are talking about multiple registered sales.
Yes, ma'am.
Yes.
But
Not
they have not brought a single sale deed.
not exhibited.
No. Now they say there was a long-term lease by Fertilizer Corporation Sindri. Now a schedule of the details of land was given in that Fertilizer Corporation of Sindri properties. There neither Khatiyar number 30 is recorded nor plot number 621 is recorded.
There is land acquisition case also.
In fact, it was not related to my land. The ISCO, Indian Iron and Steel Company, had made requisition to the state for
All the sales have been exhibited. How do you say that they will not be?
Malad.
All the sales have been exhibited.
Because they are not in relation to this. They are in relation to other plots.
No. They are whatever has been recorded. All the sales have been exhibited. You just now say that
Well,
none of the sales were
I
exhibited.
will place for some documents are with me.
No,
I will
you
place
say
for my
it is-
lord's kind
You
consideration.
see, when you say that it was not exhibited, so I was looking at the exhibits.
Alright, I will place all those below. From the judgment, I have looked that, and the appellate court below, without adverting to the evidence of the plaintiff witnesses, rather giving a wrong construction of the plaintiff witnesses, he has said that we have admitted in our evidence that possession was not with the plaintiffs. Date is important. Those who have said that plaintiff is in possession are prior to the date of forcible disposition. 13/1/2008 was the date of disposition. That I can place from the evidence of PW5, the plaintiff.
That is during the pendency of the suit.
G.
During the pendency of the suit. You did not amend the claim.
Yes, I made a complaint to the,
Did you were seeking confirmation of possession when
no,
you filed the suit. What was your suit?
a recovery of possession.
You were seeking recovery of possession. Then how the date of disposition is 13/1/2008?
Some portion was taken on 13/1/2008 forcibly. I have have said not in is evidence of PW5.
No, you see, you are seeking recovery of possession.
Yes.
With respect to the entire property.
No.
No means, let us see.
Well,
what was
I have
your-
stated at para 12 of my evidence.
No, not from the evidence. What was your prayer? You sought relief of declaration of title and recovery of possession
Yes.
with respect to the entire property. Then how do you say that on 13/1/2008 you will discuss it?
Well, 13
During the
1
pendency
2000,
of this.
yes, 13 1 2008, my lord, I have stated at para 12 evidence of Shyam Narayan Singh, the
Evidence से नहीं चलेगा ना सर, आपका claim क्या था? You were seeking recovery of possession of the entire property.
I'm giving.
And you say that you were dispossessed on 13/1/2008. How is it possible?
One more. Late pilot, it is in my hands. For decree declaring the plaintiff's occupancy right title interest over the Schedule B land. Schedule B land is the remaining land after the sale of 12 acres of land. That is 17 acre and 16 decimal of land.
That's right. So entire property you are claiming.
Yes, and for recovery of possession thereof. My
So you were claiming recovery for the entire land.
will
So
not
you
work.
stood dispossessed even on the date of filing this suit.
My lord, in fact, they were not allowing us to go to the land, for our agriculture. But
Change your stand like this.
on 13/1/2008,
It has
They-
no relevance because you claimed that you were already dispossessed on the date
Yes.
of filing the suit.
yes,
So there
yes.
is no question of further date of dispossession during the pendency of the suit.
Till then,
And moreover, you did not file any amendment petition also that something else has happened during the pendency and
They are
therefore some
villagers,
further
because
relief.
they had
They
given
are villagers.
just
Advocates are not villagers. Right.
just they had given complaint before the Jan Shikayat Koshan Dhanbal.
सर आप ना रिकॉर्ड से बहस करिए, लिटिगेंट के इंस्ट्रक्शन से मत बहस करिए।
नहीं वो it has come on the evidence. It has come on the evidence. One
आपका डिपेंडेंट आपका
one witness is Baleshwar Rana.
विटनेस से नहीं होगा। अगर आप कंप्लेंट दिए तो कंप्लेंट का कॉपी कौन सा एग्जिबिट है?
Exhibit किया हुआ है Baleshwar Rana. He is aged about 48 years. He said, I have made inquiry on the orders of Circle Officer Baliyapur by letter number 716 dated 13/2008. The inquiry report is at exhibited. That is it.
इंक्वायरी रिपोर्ट ना कंप्लेंट। इंक्वायरी रिपोर्ट है।
Inquiry report. I made a complaint to the Jan Shikayat Koshan Dhanbal. From there, the presiding officer sent it to the circle officer, and the circle officer got a inquiry made through their officers and staff, and that person Baleshwar Rana, who was employed in circle officer Baliyapur, he has made he has given a evidence. At paragraph 2 and 3, he said, I have made inquiry on the orders of Circle Officer Baliyapur by letter number 7 and 16 dated 13/2008. Inquiry report is exhibited. Now, PW1 is also one Gujar Bauri, he is 65 years old. He says that on 17 acre, 16 decimal plaintiff grew paddy and some portion rahar, makai and sabji it is. Few years early, company overnight erected wall in some area. Plaintiff objected then of the construction of erection wall, erection of walls, then it was stopped. Plaintiff have peaceful possession over 17 .16 acre of land, which I see since I gained consciousness. He has the
Sir, आपने ये petition record पे नहीं लाया है. It has been recorded by the learned appellate. And you have not brought
the learned appellate court has not even construed the evidence of the plaintiff PW5 in
आप पढ़िए appellate court का finding. Page number 21 appellate court order, sir.
finding starts at paragraph 14 of the Land Appellate Court. Land Council appearing for the appellant has submitted that the due judgment passed by the court below is contrary to law and facts and of the case, and it is liable to be set aside. The court below viewed the entire case from the wrong angle of the user and thus arrived at an erroneous conclusion and finding. In the facts and circumstances of the case, the court below should have decreed the suit brought by the
पर
evidence.
submission है,
Yes.
अपना finding पढ़िए.
Madam,
Finding starts from para 18.
madam. Paragraph 16 will have the court. Internal page 15, madam.
That you have seen.
Ah.
These are the points.
After going through the arguments of both the parties, I would like to frame following issues for consideration. This is the point for determination.
You
Number one
read,
is
you
the-
read issue number 1.
Issue number, whether the
Para 17 पढ़िए.
issue number 1, para 17, madam. Whether the finding of the court below that suit land was the reality and Helumani Devya is correct. And the Rati land of Helumani Devya is correct. In the first case, I would like to take up this issue because particular finding has been given by the court below that Helumani Devya was the Rayat of the Rayat, Hanji Kumari. And after death of Helumani Devya, her legal heir are not entitled to inherit the land in question. I have used the word peculiar as because in the written statement it is nowhere mentioned by the respondent defendants that Helumani Devya was the Rayat of Hanji Kumari. In fact, Helumani was daughter of Hanji Kumari. Neither of the parties has laid any evidence in this regard that Helumani Devya was the Rayat of Hanji Kumari. In the impugned judgment, the court below has not framed any issue with regard to the aforesaid findings, but while deciding issue number 4 and 5, the court below has given finding that Helumani Devya was the Rayat of Hanji Kumari, and after death of Helumani Devya, in the light of the settled law that the right and interest of the Rayat is neither transferable nor heritable, the land vested with the Zamindar. From perusal of the evidences available on the case on record, indicates that Helumani Devya was one of the daughter of Hanji Kumari. This is my submission.
So this issue was decided in your favor.
In my favor.
Issue number
He has held that as
issue
such
number
the
2.
number 2. Here the problem starts because the evidences of the plaintiff have been construed wrongly by law.
डॉगी मतलब आपको बताना पड़ेगा ना क्या कंस्ट्रूट होता है.
हम बताएं.
बहुत ऐसा कोई सिलेक्टिव स्टेटमेंट नहीं दे सकते.
Minor. Whether the appellants, plaintiffs have right title and interest over the suit land and they are entitled to get its vacant position after vacating the defendants from them. May I pause for a moment, my lord? If I am one of the daughter of the recorded tenant and it is held that we were not the Rayat, so it has devolved upon us.
Provided you have not sold it.
Where Baker has
We
been
do
sold.
not know. There are so many savings mentioned.
Oh, those sales are not by the plaintiff.
We do not know.
If somebody sells my land, that will be just carrying a bag of beans, nothing more.
But there is no such declaration also.
Well,
There is no such relief seeking a declaration with regard to those registered checking.
my lord, they wanted to.
आप पढ़िए सर ऐसे नहीं आप पढ़िए
Whether
just
they
read the
apply-
finding and जहाँ पे आपको लगे perversity है बस वहीं रुक जाइए
See,
और आपके पास जो डॉक्यूमेंट है दिखा दीजिए.
this is the most important issue involved in this civil appeal, which I would like to adjudicate now. As per the case of the appellant plaintiffs, CS plot number 621, Khata number 30 was Rayati land. Some Srimati Khanju Kumari was with Khanju Kumari, wife of late Jural Dev, who was in possession thereof, and after her death, the land was inherited and purchased by her only daughter, Hirumani Devya, who is grandmother of the plaintiff number 1. That is Ram Singh, my present present appellant's father. In this regard, I would like to refer one gift deed, Exhibit 14, executed by Nuna Kumari, Chunki Kumari, and Manchuran Kumari, all daughters of late Juran Dev in favor of Devabrat. This Devabrat was grandfather of this plaintiff. This document has been brought on record by the appellant. The result of this document clearly indicates that Khanju Kumari, who is wife of late Juran Dev, had other daughters also, apart from Hilmani Devya, and this submission of appellant plaintiff is palpably false that Hilmani Devya was only daughter of Khanju Kumari. And after death of Hilmani Devya, her son Devabrat was in possession of the land in question, and by solely dated 8103 and 8104, dated 1/6/1964, Exhibit 9 and 9/1, he sold 12 acres of land to one Syamal Kumar Mukherjee, nominee of defendant number 1, that is Indian Iron Steel, who later on built quarters etc. there. In this regard, I would like to
Devbrat जो है Devbrat is son of Hilmani Devbrat.
जी,
Right, and this Khanju Kumari had this Juran Dev had many daughters.
3 daughters, all 3. But finally, my lord, find Exhibit 6 by Exhibit 14, all the sisters, including Helumani, had given the land to Devbrat. तो मिल तो फिर वही आ गया. Maybe Exhibit 14 executed by Nuna Kumari, Chunki Kumari, and Manchuran Kumari.
आगे पढ़िए नहीं क्या है.
In this regard, I would like to see the service executed by Devbrat in favor of Samuel Kumar Mukherjee, which are Exhibit 9 and 9/1. In the version, both the deeds have been filed by the appellants, which are on record on the case report. Perusal of para 5 of these deeds indicates that this Devbrat Singh had only 12 acres of land in his possession in plot number 621, because in both the deeds it is written that Mauda 158 Khata 30 plot 621 record 29.16 होना चाहिए and 16 decimal है, लगभग 29 एकड़ होना चाहिए. निजांस से मेरा निजांस 12 एकड़, उसमें से आज दलील में आप ही को 6 एकड़ बिक्री के बाद बाकी 6 एकड़ में उसके ऊपर बना हुआ कच्चा मकान, कुआं आदि मिक्स बगीचा में सब आपको आज इस दलील से बिक्री की. It would be pertinent to mention that by both the deeds, 6 acres of land were transferred by in favor of Syamal Kumar Mukherjee, defendant number 1.
So whatever was given to Devbrat Singh by virtue of Exhibit 14 was sold.
So we can read Exhibit 14. It is on record. That is the wrong construction. 29 acres, 16 acres was given to Devbrat. Court says
ये क्या wrong? ये क्या?
yes.
This is wrong.
Yes, my lord.
Show me
It
Exhibit
is.
14. That this quotation is wrong.
I will read for my lord's kind consideration Exhibit 14. The दान दाता नूनामणि चुनकी कुमारी और मंचूरन कुमारी पिता स्वर्गीय जुरन देव जाति राजपूत पेशा सत्यन सच दान ग्रहीता श्री देवव्रत सिंह पिता स्वर्गीय शांतिलाल सिंह सत्यन सच थाना झरिया सुरनसो जाति सुरनसो तफसील मौजा नंबर 1600 खाता नंबर 1600 वाला परिमाण 18.18 एकड़ 40 डिसमल 18 एकड़ 40 डिसमल खाता नंबर 67 परिमाण 14 एकड़ 14 डिसमल पक्षों के दलील द्वारा सुना है so this is not only with regard to 6 acre
सर
of
आप हमको ये पोर्शन पढ़ के सुनाइए कि या ये पोर्शन इसमें गलत लिखा है Is
मतलब
it wrongly recorded?
this recording is
Show me exhibit 14 आप तो समझ ही नहीं
exhibit 9
ये
and
जो यहाँ हिंदी में कोट किए हैं
हाँ वो exhibit
गलत-
9 और 9/1 से कोट की है
9 and 9/1 में जो उन्होंने बेचा है ना
हाँ
उसी में से कोट किए हैं
1 minute I will give you this is पूरा बांग्ला से हिंदी अनुवाद डीड नंबर 8103 dated 1664 केवाला दाता is देबू सिंह पिता so and so the grandfather of the plaintiff केवाला ग्रहीता श्यामल मुखोपाध्याय माइनर विक्रय केवाला दलील खास विकृत संपत्ति मूल्य सर्जन से तफसील जिला सर्जन से मौजा खाता नंबर 30 प्लॉट नंबर 621 रिकॉर्ड 29.16 एकड़ निजांस में से मेरा निजांस 12 एकड़ उसमें से आज अन्य दलील में अभी को 6 एकड़ बिक्री के बाद करके बाकी 6 एकड़ मैं उसके ऊपर बेच रहा बना हुआ कच्चा पक्का मकान वृक्ष सजन सच कुआं आदि दे रहा हूँ विपरीत संपत्ति का सालाना लगान सज्जन सच so the learned court has concluded that this was only 6 acres of land this contains the land which is being transferred by deed number 8103 वो लिख रहे हैं कि पहले 6 एकड़ दिए थे अभी फिर 6 एकड़ दे रहे हैं 81 I think 8104 was signed earlier and 8103
exhibit 14 दिखाइए
that contains even more lands than 29 acre and 16 acres.
ये ऐसे सादा में ऐसे सर्टिफाइड कॉपी
मैडम
इसका सर्टिफाइड कॉपी नहीं फाइल हुआ है ऐसे सादा
नहीं हुआ था वो बंगला में था तो हिंदी ट्रांसलेशन हुआ इसका and the scribe has given a signature on the side of this. Date is also given, deed संख्या Deed number 1500 dated 18/4/39, 1939 का deed. It was in Bangla, later on it has been translated by B.N. Karmakar, Advocate Dhanwa, at the last year later. मोट 38 प्लॉटों का परिमाण 18.408 डिसमल, 18 एकड़ 40 डिसमल. खाता नंबर सेकंड साइज समिला प्लॉट नंबर 14 एकड़. Vote saying that it contained only 6 acre or 12 acre is in fact incorrect. And in the LCR all the documents are there. अब लिख रहे हैं कि निजास उसमें से आज दलील आपको 6 एकड़ बिक्री कर रहा है, तो उनको लगा कि 12 में से 6 एकड़ बेचा, तो 14 एकड़ है एक जगह और एक जगह 18 एकड़ 40 डिसमल, 32 एकड़ 40 डिसमल.
ये कौन सा है खाता नंबर किसका?
खतियान नंबर लिखते हैं. हम तो आज तक खतियान नंबर जानते नहीं थे, बट वो खतियानी नंबर बोल रहे
ये
हैं.
आपका प्रॉपर्टी कौन सा खाता नंबर है?
इट इज इन खाता नंबर 30 एज पर द प्लेट.
इसमें जो दान पात्र है उसमें खाता नंबर 28 है.
उस समय में होगा दान के 28 नंबर खतियान लिखते हैं.
और खाता नंबर 31.
हाँ, तो 1939 का है, वो बाद में बदल गया होगा. Things changed afterwards. बाद में रिविजनल सर्वे भी हुआ था लेटर ऑन. अब कोर्ट का ये कहना है कि 12 ही एकड़ है, ये तो गलत है.
Gift deed was claimed by whom?
My lord?
Plaintiff. The gift deed was claimed by the plaintiff. Exhibit 14.
Exhibit 14 was executed by daughters of Khanju Kumari.
आपका ये गिफ्ट डीड के बारे में आपका प्लेट में से नहीं पता चला.
In fact, my lord,
There
that
is-
contained larger area.
No.
Now only plot
No,
number
I just want-
621 is under consideration.
Maybe, but there is no amendment regarding the gift deed in your claim.
In fact,
Is
my
there
lord,
any
it
amendment?
was, in fact, it was brought by additional evidence in the appeal.
You bring it by way of additional evidence without any foundational pleading.
No,
If
it
you are
was,
claiming some property by virtue of a gift, there has to be a foundational pleading.
in fact, my lord, what is the fact, my lord, that I belong to the family. Gift deed, I will read from my lord's kind consideration a few lines that will prove that
Where is the discussion of additional evidence by the applicant?
regarding exhibit 14, the court says, but it doesn't say that it is additional evidence. It has come in additional evidence. The record shows that it was brought by additional evidence. Okay.
This is not correct.
Well, exhibit 14,
No, exhibit 14 is there in the title suit also.
my lord will find. It was, petition was filed on 6th of April 2017. Suit is of the year 2004.
सर ट्रायल कोर्ट का जजमेंट तो देखिए, उसी में एग्जिबिट 14 का जिक्र है ना,
एक
पेज नंबर 4 में देखिए.
one
सर रिकॉर्ड के बाहर बोलने से ना हमको एकदम मतलब समझ ही नहीं आता है क्या क्या बोलते हैं. एडिशनल एविडेंस एग्जिबिट 14 इज वेरी मच देयर इन द ट्रायल कोर्ट्स जजमेंट.
I cannot say.
I don't know, it is mentioned in the trial court's judgment.
Trial court also said that we are the Dariyas.
Exhibit 14 is there in the trial court's judgment. Certified copy of the registered gift deed number 1500 dated 18/4/1939 by Nunu Kumari and others in favor of Devrat Singh.
1 minute. Let me come to that.
मिला पेज नंबर 4.
Page number 42.
Page number 4 of the trial court's judgment.
4. Right. Certified copy of registered gift deed number 1500 dated 18/4/1939 by Mona Kumari and others in favor of Devabrat. Devabrat is my grandfather.
That's right. आप ये जो बोल रहे हैं कि appellate court में ये additional evidence आया है,
इसको
सर आपके रिकॉर्ड से हम नहीं चलेंगे ना.
ये तो कोर्ट का रिकॉर्ड हो गया ना.
कोर्ट का कैसे रिकॉर्ड?
फाइल
ये क्या सपना आ रहा था ट्रायल कोर्ट को? एग्जिबिट 14 लिखते समय ये बहुत सीरियस एलिगेशन है अगर आप ऐसा बोल रहे हैं.
हम
How
allegation
serious it
नहीं
can be? नहीं, how serious it can be? Exhibit 14 is very much recorded in the
You
trial
have
court's
written
judgment.
that while in this petition, your petition was leave to produce documents marked and the same as exhibit. Oh, earlier it was marked exhibit X, later on it was marked by order number 10/4/2017 as exhibit 14. Pursuant to the aforesaid liberty given by the court, the plaintiff have filed gift deed. Yes, in the title suit itself. Gift deed dated 29/6/1935 and 18/4/1939 as per a separate list of documents dated 4/4/2017 as documentary evidence in rebuttal. So it was not later on given in the title suit.
Whatever it is
I
very
stand
much
that.
there in the title suit.
The
आप
gift deed,
एडिशनल एविडेंस की बात कर रहे हैं, हम तो पूरा जजमेंट पलट लिए, हमको तो कहीं दिखाई नहीं एडिशनल एविडेंस का कोई काम.
In fact, the wordings have been used for leave to produce documents and mark it as exhibit. It is written, but it is in the trial court. The Court of Civil Justice Senior Division number 6 Dhanbad at suit number 126 of 2004. Petition for leave to produce documents and mark the same as exhibit. While allowing the amendment of written statement of the defendants, Your Honor has been pleased to give liberty to the plaintiff to adduce evidence in rebuttal that pursuant to the aforesaid liberty given by the learned court, the plaintiffs have filed gift deeds dated 29/6/1935 and 18/4/1939 as per separate list of documents dated 4/4/2017 as documentary evidence in rebuttal. The gift
You
date.
see, the trial court has also recorded that this gift deed is relating to Khata number 28 and 31, and the suit is in relation to Khata number 10. That objection has been recorded by the learned trial.
Yes,
Then,
as my lord also.
then this gift deed has got no value. Then this gift deed is of no consequence.
You know, for a moment, for argument's sake, if that is also accepted, but I am a descendant of Hanju Kumar. Hanju Kumar's daughter was Helumani. Helumani's son was Devabrat, and Devabrat's son was Ram Singh, who was the plaintiff in this case. Now I am Syam Singh, grandson of Devabrat.
See, you are claiming the entire property by virtue of the gift deed
Look,
executed
that
in
is-
favor of Devbrat.
that-
Because Helumani had other daughters also.
They also.
They are party in the proceedings.
No, they also associated, and they also said that
When they deposed before the court, they are not party to the proceedings.
they are not party, but
Because they were not made party because you were claiming this property through this gift deed.
in fact, all the three other sisters of Helumani,
Yes, they were not made party.
in fact, the other three sisters of Helumani also jointly gave this property by way of gift.
Jointly is
To Devbrat.
कहाँ joint? ये जो property जो gift मिल गया Devbrat को, it is not relatable to the suit property.
My lord, plot number, खाता number changes in.
Changes मतलब आपको evidence लाना पड़ेगा ना कि ये खाता नंबर पहले था, उसके बाद नया खाता नंबर corresponding ये हुआ. कहाँ है? Rather आपके पूरे plate में कोई pleading नहीं है gift deed के बारे में.
In fact, मेरा कहना है कि खाता नंबर 30 belong to Hanju Kumari. She was succeeded by her daughters, Helumani, and maybe 3 more sisters of Helumani. But subsequently, they all jointly gave it to Devbrat.
Which is that document?
And
Which is that document that khata number 30 was given to Devbrat?
there is one document
Which document?
of 1935. Of
Exhibit
1935.
number बताइए. और exhibit दिखाइए.
Well, that is stated. That is stated.
Stated नहीं आप exhibit दिखाइए. क्योंकि आप जितना भी बहस कर रहे हैं ना एकदम mismatch हो.
I will place
आपका हर point एकदम mismatch हो.
even the oral evidences have been overlooked.
Oral evidence जो documentary evidence अगर मान लीजिए कोई gift की बात हो रही है, कोई transfer की बात हो रही है, तो उसमें documentary evidence आएगा ना.
सक्सेशन से हमको मिली, अगर नहीं भी मिलता सक्सेशन से हमको मिली.
और अगर आपको succession से मिला तो आप पूरा property तो नहीं claim करेंगे ना succession से. Because there are 3 more sisters.
They are not coming.
They are not party.
When the
They are not party to the
property
proceedings.
has been usurped, forcibly taken possession of by the defendant, they may have filed any other case.
I do not know. May have मतलब.
They have not
Partition
filed.
suit आपका pending है.
will not go subsequent time क्या है?
Subsequent नहीं
2015
कभी
का है।
कभी वो partition suit तो कभी भी फाइल हो सकता है।
कभी हो सकता है।
That partition suit is
2015
pending.
का है।
That partition suit is pending. That partition suit number 307 of 2015 is pending.
2015.
कभी भी फाइल कर
This
सकते
is the
हैं।
suit of 2004.
It makes no difference.
My lord, may kindly allow me to place that gift deed dated 29/6/1935 is the Xerox copy from its original, which original has been filed in title particle suit number 307 of 2015. And as such, the Xerox copy may be marked as X for identification. Registered gift deed number 1500 of 18/4/1939 is a certified copy which has been obtained from Registry Office Dhanbad, which will be marked as Exhibit 14 on behalf of the plaintiff. So, look, they have tried their best. It was filed in April, and in August 2017, my lord, the judgment has been delivered. Maybe that this document of 1935, which has been marked as an Exhibit X, could not be obtained by the plaintiffs during that period from the registry office. They could obtain it from the registry office, the deed number 1500 of 18/4/1939. They brought it before the learned court below. And my lord, we find from the evidences considered by the learned appellate court, and my lord,
Specifically, arguments concluded.
my lord, I have to place the judgment in respect of.
सर आप जो भी बोल रहे हैं सभी एकदम ऐसा मिसमैच है कि हम क्या बोलें।
My lord,
आप उस पर
Evidence of-
एडिशनल एविडेंस पर 10 मिनट बहस किए और पता चला वो एडिशनल एविडेंस है। ये सब सारा चीज हम लोगों को देखने का है। मतलब we take your words for as correct.
my lord,
लेकिन आप कुछ भी बोलते हैं।
my lord, I have
इससे
to
ज्यादा नहीं।
place oral evidences, my
ये
lord.
oral evidences का कोई मतलब नहीं।
In fact, it is wrong construction.
Means
Wrong construction of evidences,
आप
my
जितना
lord.
भी बहस किए सब चीज आपका रिकॉर्ड से मैच नहीं करता।
I will place those
तो
documents.
प्लेस करिए ना।
अभी तो what my lord said, I have placed it.
नहीं,
But what I want to place, that is still pending.
What do you want to say? I want everything. जो भी आप
Evidence.
बोल रहे हैं सब आधा घंटा से आपको सुन रहे हैं। आप जो भी बहस कर रहे हैं सब बियॉन्ड द रिकॉर्ड बहस।
Ajuri ने कहा कि उसको place कीजिए. I want to place the plaintiff witnesses.
प्लेंटिव विटनेसेस ऐसे नहीं प्लेस होता है सर। सेकंड अपील में है आप हमको बताइए कौन सा विटनेस का
हाँ ठीक
एविडेंस का
है. हम
परवर्सिटी
place करेंगे कि इन्होंने क्या
कौन सा
लिखा.
विटनेस का एविडेंस का परवर्सिटी
PW5,
PW5
PW1, PW1 and PW3.
अब सभी प्लेस कर दीजिए। परवर्सिटी हमको बताइए क्या परवर्सिटी
Yes.
और कौन सा ऐसा डॉक्यूमेंट
I
थिंग्स आर
will
बेसिकली
place-
बेस्ड ऑन डॉक्यूमेंट्री एविडेंसेस।
I will place that.
आपका ये जो पूरा कहानी है एकदम डिफेक्टिव।
My lord,
The gift deed का कहानी is absolutely mismatched.
when one goes to show the illegalities, he has to place the
आप बताइए ना किसका एविडेंस का परवर्सिटी है
my lord.
और कौन सा पैराग्राफ गलत लिखा गया है जजमेंट में। आपको ये बताना पड़ेगा कि ये स्टेटमेंट पीडब्ल्यू का 5 का जो रिकॉर्ड में
Well-
लिखा हुआ है वो गलत है।
My lord.
बताइए व्हाट इज दैट।
At page internal page 6, my lord, you find PW5 Shyam Narayan Singh, appellate court.
आप बताइए क्या गलत लिखा है।
PW5, my lord,
इंटरव्यू पेज 5
internal page 6. PW5 Shyam Narayan Singh has in para 7 of his cross examination says that he made
इंटरव्यू
corresponding.
पेज 6 में तो ये है ही
Huh?
एप्लेट कोड जजमेंट में तो ये है ही नहीं। कहां पर है?
Just
एपिलेट कोर्ट जजमेंट में दिखाइए कि PW5 का कौन सा एविडेंस का कौन सा चीज गलत लिखा।
एक running page, my lord. Running page is 40. This is a trial court judgment.
Appellate court judgment पढ़ी है सर. अब appellate court के बाद क्या trial court judgment? Appellate court judgment has considered everything.
My lord will kindly consider. My lord will find, while deciding issue number 2, the London Appellate Court has not taken into consideration the evidences of the plaintiff, that is PW5.
Trial court में कहाँ?
Trial court में
कहाँ है बताइए?
page 40. And appellate court has not looked into it.
जब concurrent filing होता है तो हर चीज देखने की बहुत ज़्यादा ज़रूरत नहीं है. आप हमको बताइए
Concurrent
trial
finding
court.
in the appellate court का finding तो
आप
मर्ज कर
हमको
गया.
बताइए.
Appellate court का judgment तो मर्ज कर गया.
मर्ज नहीं करता है सर. बात यह है कि आप हमको दिखाइए कि ट्रायल कोर्ट में कौन सा एरर है PW5
ठीक.
और कौन सा स्टेटमेंट आप पढ़ रहे हैं PW5 जो गलत लिखा गया है. पैरा नंबर बताइए.
I will read from PW5.
पैरा नंबर बताइए.
Para number of the evidence.
हाँ, फिर आप हमको बताइए इसमें
Para
कहाँ गलत रिकॉर्डिंग.
Para
और
12
कितना
of
मटेरियल है वो.
Para 12
PW5 कौन है? Who is PW?
श्याम नारायण सिंह, the plaintiff.
The plaintiff. Okay. What is
मैं श्याम नारायण सिंह
हाँ.
इस मुकदमे का वादी संख्या 2 हूँ और वादियों की तरफ से मैं ही इस मुकदमे का देखभाल कर रहा हूँ. Now subsequently he said at para 12 यह कि प्रतिवादी गण द्वारा 31/1/2008 वादी के खेती योग्य जमीन पर डोजर चला के करीब 5 एकड़ जमीन को क्षतिग्रस्त कर दी, जिसकी सूचना जिला जन शिकायत कोषांग धनबाद को लिखित शिकायत दर्ज मेरे द्वारा किया गया, जिसे प्रभारी पदाधिकारी जन शिकायत कोषांग धनबाद द्वारा जांच हेतु अंचल अधिकारी बलियापुर को भेजा गया और अंचल अधिकारी बलियापुर द्वारा जांच के बाद प्रतिवेदन जमा किया.
सर ये स्टेटमेंट का कोई वैल्यू इसलिए नहीं है because you have sought recovery of possession of the entire suit property. Then how do you say that ये तो आपको पहले ही
नेचर ऑफ
आप दे दीजिए हम उस एविडेंस को कंसिडर.
मतलब टुमारो
नहीं टुमारो नहीं.
टुमारो हम इसको कंक्लूड कर देंगे.
कोई जरूरत ही नहीं.
बिना आधा घंटा लगेगा हम कंक्लूड कर देंगे.
इतना आधा घंटा सब्सटेंशियल क्वेश्चन ऑफ लॉ में नहीं लगता. ऐसे नंबर 463 ऑफ 2018.
तो हमको बहस करने का मेरे पढ़ने का कोई पर्पस नहीं हुआ. आप ही ने कहा कि दिखाइए. आई नेवर वांटेड
आप
टू
दे
शो
दीजिए ना हमको, हम उसको देख लेंगे.
माय लॉर्ड, हम लेट मी हैव द सैटिस्फैक्शन ऑफ
वो सैटिस्फैक्शन आपको
at least
सर सेकंड अपील
the
में
right of a
इस तरह
lawyer
से
must be
right of a lawyer.
exercised.
I am giving you the full right and you are misusing it.
नहीं,
Because
आपने कहा कि
you are-
पढ़ दीजिए.
No.
एग्जिबिट 14 पढ़िए.
Yeah, you are misusing it for half an hour by making submissions which are beyond the
In
records.
fact, my lord said that I should place it exhibit
No,
14.
I just wanted to know that what is it that you want. So, exhibit 14 is total mismatch
ठीक है.
because exhibit 14 is not relating to the suit
Lord,
property at
I
all.
say even exhibit 14 or the exhibit of 1935, both are mismatched. I am the successor. My maternal great grandmother.
You are not the only successor. You have sold your portion of property.
हमारे हिस्सा में से हम लिखे.
आपके हिस्सा में से
समझ
आपका 12 एकड़ या जितना था आप ऑलरेडी बेच चुके.
गया. ये कोर्ट का कहना है.
आपका
मेरे
भी तो यही
गवाही में
कहना
नहीं है.
आपका भी तो यही कहना है.
नहीं, मेरे नहीं.
A registered safety day is not sufficient.
My lord, मेरे गवाही में नहीं है.
बस हो गया. देखिए ऐसे नंबर 463 और
अब
2018
तो बहुत मुश्किल है, तब तो बहस नहीं कर सकेंगे.
कोई बात
नहीं कर सकेंगे. In fact, if I am not allowed to place the evidence,
I am listening to it. The learned counsel for the appellant.
I may be allowed to place it tomorrow. I don't say I seek time, because the time is already over. I cannot say that my lord may invest any more time here. Tomorrow my lord may hear it at 10:30.
आप किसका एविडेंस प्लेस करना चाहते हैं? आप इतना तो बताएंगे ना किसका
हाँ.
एविडेंस किसका?
PW5, PW1, PW3.
पैरा नंबर बताइए.
Para 12 and 13 of PW5, which shows.
Just a moment. PW5, पैरा 12 and 13.
12 and 13.
और बताइए. और बताइए.
1 minute. PW5, his date is important, 28/8/2008, that after the bulldozer was.
Okay, आगे बताइए.
28/8/2008,
और
he says at para
हम
12.
सुन लिए. और बताइए.
उसको पढ़ तो देखा ना.
हम सुन लिए कि इस तारीख को आपको डिस्पोजल किया है.
बालेश्वर राणा, उसका PW नहीं लिखा हुआ है, but the evidence is with me, certified copy is with me. PW नहीं लिखा हुआ है. बालेश्वर राणा is at 48 years. He is staff of CO office. He says that I had made inquiry on the orders of Circle Officer Maliapur by letter number 716 dated 13/2/2008. Inquiry report is may be made exhibit so and so. Then, in fact, up to 2002 say we are giving it by way of an affidavit. So we say make it an exhibit.
पैरा नंबर बताइए.
This is in the beginning, para 2 and 3.
2 and
2 and 3.
he talks about inquiry report.
Yes. Then PW1 is Gujar Lal Bauri, 65 years of age. He says he at para 7 that on 17.16 acres plaintiff grow paddy and in some portion rahar makai sabji etc. Then at para 8 he says few years earlier company overnight erected wall.
Para 17.
Para 8.
Para 8 and 17.
Then para 7, then para 8 of PW1. Gujar Lal Bauri, he is a 65-year-old man, quite responsible person. Para 7 he says on 17.16 acre plaintiff grow paddy and in some portion bahar makai sabji etc. Para 8 he says few years earlier company overnight erected wall in some area. Plaintiff objected, then erection of wall was stopped. Then at para 10 he says plaintiffs have peaceful possession over 17.16 acres which I see since I gained my consciousness. जब से होश हुआ 65 साल का आदमी है. Then he says he in cross examination he says there are 12 of the evidence in cross examination. मेरा खेत 2-3 प्लॉट के बाद है. So he is adjacent right here.
Yes.
Para 16 and 17 he says company का क्वार्टर 40 साल पुराना है. That is over my 12 acres which I had sold in 1964. Para 32 40-45 वर्ष पहले.
You want to say that you are in possession of the property.
On the date of filing of the suit, I was in possession. On the date of filing of the suit, I was in possession. In some portion, they had erected some wall, etc.
On the date of filing of the suit, you claimed possession. You claimed recovery of possession.
From the some area. From some
No,
area.
it is not there. From some area. You claimed recovery of possession of the
Yes.
suit property.
Yes.
Right? And during the evidence, you
Agar
say
hum-
that you were in possession of the
Suppose
property.
we were, if some portion is in their possession,
Sir, some portion in their possession का कहानी आप नहीं बनाए हैं सुन.
my lord, suppose my lord, I claim for
Sir,
recovery
please
of-
तो हम जान सकते हैं, लेकिन आपका submission हम record करें. The learned counsel for the appellant has submitted that the improved judgments are perverse inasmuch as the evidence of PW5, PW1 and PW5
PW2, Durga Das Oza.
the suit. तो PW2 तो आप बोले नहीं. सर हमको 6 भी बच जाएगा ना, आज हियरिंग खत्म करके इसलिए नहीं. आपको जितना बहस करना है
आपको दे दीजिए.
क्या
इसी में सब लिखा हुआ है.
इसी में लिखा हुआ नहीं, एविडेंस दीजिए ना, उसे लिखा होने से क्या
तो एविडेंस भी दे दीजिए.
दे दीजिए.
सर्टिफाइड कॉपी है, हम दे
दे दीजिए.
This is PW1 to PW7.
PW1 to PW7 ऐसे नहीं, आपने तो PW5 आप प्लेस किए हैं. ये बालेश्वर राणा कौन है पीडब्ल्यू?
अब उसका नाम नहीं लिखा हुआ है, वो नंबर नहीं लिखा हुआ है।
हम बता देते हैं,
I'm
इंप्यूट ऑर्डर
guessing.
में तो रहता है ना सर
जी?
वो हम खोज के आपको बता दें। अगर आप नहीं खोज सकते हैं तो कोई बात नहीं।
He is PW7.
PW7 and PW1 करेक्ट?
नहीं, और भी लोग ना,
और मतलब सर इस तरह से नहीं होता। तीन विटनेस आप बोले थे, हम तीनों विटनेस आपका रिकॉर्ड।
they have not been considered. So I
So
say,
you claim that being the plaintiff, you were already in possession of the entire property. यही बोलना चाह रहे हैं ना?
Milord.
And you were disposed on 28/8/2008.
28/1, 13/1, 13/1,
ये सारे एविडेंस आप
5 acre land was.
सर ये सारे एविडेंस आप इसीलिए प्लेस कर रहे हैं ना? That you were disposed on 28/1/2008 and you were in possession of the property to the extent of 17.16 acres. इसीलिए प्लेस कर रहे हैं?
नहीं, on the date when bulldozer was plowed in,
हाँ वही 28/1/2008
damage of the plot हुआ है।
ठीक है, डैमेज ऑफ द प्लॉट हुआ है, यही आप बोलना चाह रहे हैं ना कि 28/1/2008 को यू वर डिस्पोजेस फ्रॉम द सूट
Yes.
प्रॉपर्टी, राइट?
नहीं, अब उसके पहले जो डिस्पोजिशन था उसके बारे में तो हम लिख कर दे रहे हैं ना, गवाही है मेरा। इनफैक्ट PW5 has given evidence on 28th of August 2008 and he says at paragraph 12 that defendants have destroyed the land and damaged the agriculture on about 5 acres. Not that I was in possession and they have already forcibly dispossessed me. What has been used? They have encroached. That may be a situation when a person may use encroachment of land. Encroachment एक प्राइवेट पर्सन से क्या एनक्रोच करेगा? सरकार से एनक्रोच करता है लोग। प्राइवेट पर्सन एनक्रोचमेंट एक्ट नहीं है, पब्लिक लैंड रिकवरी एक्ट एनक्रोचमेंट एक्ट होता है। पैरा 12 में कहते हैं
PW5 आपका नोट कर लिए हैं, PW7 आपका नोट कर लिए हैं, PW1 आपका नोट कर लिए हैं। अब कौन सा PW बचा जिसको आप नोट कराना चाहते हैं?
PW2 also says कि
पैरा
बाबा
नंबर
का
खाली
जमीन
बता
बेच दिए, क्वार्टर बनाया।
PW2 का पैरा नंबर बताइए।
PW2 बराबर
पैरा नंबर
6।
पैरा 6।
हाँ।
ठीक,
बाकी 17.16 एकड़ वादी के कुछ खेती योग्य है, धान लगाते हैं वगैरह। पैरा 7 नाजायज ढंग से रातों रात दीवार बना दिया, ये बात लिख रहे हैं। हम नहीं कर रहे हैं कुछ दिन डिस्पोजेस में, डिस्पोजेस पहले से किए हुए हैं। नाउ दे आर चेंजिंग द नेचर ऑफ प्रॉपर्टी। फिर कहते हैं 17 पैरा 8 माइनस 17.16 एकड़ पर वादी का अंतर बराबर शांतिपूर्ण दखल रहा है।
एकदम रहा है आपका। यही
Then in cross examination he says कि मुकदमा के दौरान 21/1/2008 को पैरा 17 में कहा है ये कि जमीन पर डोजर चलाकर
एक जगह 28/1 है, एक जगह 31/1
नहीं 31/1
एक जगह 28/1 लिखा है ना?
तो नहीं 28/8/2008 को मेरा गवाही है। प्लेंटिफ नंबर 5
डेट ऑफ
डिफेंडेंट
डिस्पोजिशन
नंबर
इज 31
31/1/2008 as all have been consistently misunderstood by the learned appellate court.
ठीक, the learned
And
counsel
therefore
for
the issue
just a
number-
moment. The learned counsel for the appellant has submitted that though there are concurring findings recorded by both the courts, but the learned courts have miserably failed to consider the oral evidence of the PW5, para 12-13, PW7, para 2 and 3, PW2, para 6 and 7, PW1, para 7, 8 and 9, to submit that the bulldozer was used in the suit property on 31/1/2008, and these witnesses have stated that the plaintiff was in possession of the remaining area, that is 70.16 acres of land.
This I don't say. I say they have damaged my lands.
They have damaged your land, and these witnesses have said that you were in possession of 17.16 acres, right?
Then, my lord,
He has submitted the evidences during the court proceedings. like for orders they have to do.
Serial number 30 mention कीजिए
हाँ बोलिए.
serial number 30 मार्निंग में mention कीजिए
सीरियल नंबर
30
दे दीजिए.
Item 30.
इसमें आई एम गिविंग इट टू द क्लाइंट।
आप दे दीजिए सर, आपको परसों वापस मिल जाएगा.
नहीं मिल जाएगी, इसमें थोड़ा सा ना टैग कर दीजिए, इसमें हाथ में
अभी
लग जाएगा,
अभी
अब हाथ में लग नहीं जाएगी।
डिले दो ये फाइल टू आईज लॉक्स serial number
If Malad is fixing the case, they are
not fixing, I am fixing it for judgment.
judgment. Malad, I say
orders के लिए बनाना होगा बना देंगे, नहीं बनाना होगा नहीं बनाएंगे. सबस्टैंशियल क्वेश्चन ऑफ लॉ ही तो बनाना है. हाँ बोलिए.
कल के लिए
हम बोले ना 8 बजे तक भी सुनेंगे आज. कल के लिए
ऐसे कहाँ बोले, अभी बोले
6 बजे तक बोले थे, अब 8 बजे तक बोले. हमको बोलने में कोई
उसमें
कंफ्यूजन.
मुश्किल हो जाएगा, हम कर सकते हैं बस।
ये फाइल 1 IA लॉक्स आई नंबर 3229 there is delay of
केस देखिए वो सीनियर सिटीजन आए हुए हैं.
हाँ उसी केस में
उसी केस में.
उसी केस
हाँ
में
बोलिए क्या बोलना है आपको.
there are two IEs locks ये फाइल 1 I number 3229 of 2025
हाँ.
there is delay of 15 days in filing the second appeal
यस रिस्पोंडेंट, आपको डिले पे ऑब्जेक्शन है.
जी हुजूर,
बताइए 18 दिन का डिले पे क्या ऑब्जेक्शन है.
18 दिन नहीं हुजूर, ये डिग्री जो जजमेंट जो पास हुई was passed on 31/7/2024 and thereafter your worship on 6/8/2024 degree was made and your worship
देखिए हमारा ये कैलकुलेशन है, हमारा ऑफिस कैलकुलेशन करता है.
जी
इसमें कैलकुलेशन है, आपने देखा है.
तो नहीं
हमारा ऑफिस कैलकुलेशन करता है. इस कैलकुलेशन में मिस्टेक आप देखिए लिखा ही. ये हमारे ऑफिस का कैलकुलेशन है. 18 दिन करेक्ट.
जी
ऑब्जेक्शन है आपको.
ऑब्जेक्शन तो है
क्या ऑब्जेक्शन.
ऑब्जेक्शन ये है कि ये जो उनका जो है
आपके काम अच्छा बताइए क्या ऑब्जेक्शन है 18 दिन के डिले में आपको.
जो इनका जो पिटीशन है इसमें जो है ना इन्होंने जो ग्राउंड बनाया है उस आधार पर जो वो कहते हैं कि पैरा नंबर 4, 5 and 4 to 7 देख लीजिए इनका पिटीशन 4 to 7 देख लीजिए. पहले कहते हैं कि एडवोकेट करें जो है ना वो सर्टिफाइड के लिए सर्टिफाइड कॉपी के लिए अप्लाई किया है. फिर कहते हैं जो कि वो फिर उनकी माँ की तबीयत खराब हो गई
तबीयत खराब हो ही सकती है.
तो नेटिव प्लेस में चले गए. आप उसके बाद फिर उधर से वो आए, उसके बाद सर्टिफाइड कॉपी दिए हैं. तो मेरा ये कहना है कि एडवोकेट कलर का नाम भी नहीं है. अच्छा जिस जगह पर वो गए हैं उस जगह का नाम भी नहीं है, कोई मेडिकल रिपोर्ट नहीं है मदर का. इसमें कैसे
IA number 3229 of 2025. Counsel for the parties are present. This petition has been filed. For आप एडवोकेट हैं.
जी हुजूर,
मैंने सुना है इसमें इन पर्सन कोई एप्लीकेट.
मेरे पापा है वी आर रेस्पोंडिंग दिस केस.
Counsel for the appellant is present. Counsel for the respondent is present in person. Along with his son. ठीक है. आप तो अपीयर नहीं हो सकते हैं, बैंड लगा के आप उनका रिप्रेस नहीं कर सकते. आपका वकालतनामा है.
जी है
आपका वकालतनामा है.
जी आरएम खुजाम लिखा
ठीक है. Counsel for the parties are present. This implementary application has been filed for delay of 18 days. The counsel for the appellant has referred to the statements made in the implementary application. And as paragraph 5 to 4 to 7, and has submitted that on account of unavoidable circumstances, there has been a delay in filing the appeal. The learned counsel for the respondents has opposed the prayer and has submitted that the explanation is not supported by evidence, by supporting documents regarding the illness of the mother of the किसकी mother?
एडवोकेट करे की मदद.
Of the mother of the advocate clerk. After hearing the learned counsel for the parties, this court is of the considered view. This court is satisfied with the cause shown in the interlocutory application, seeking condonation of delay of only 18 days in filing the appeal. being satisfied with the cost shown, IA number 329/2025 is hereby allowed. अब बताइए क्या करेंगे?
Another is 616.
दूसरा IA
For the stay of execution case law, since the second appeal is not been admitted, I am only paying law. Let the second appeal be come under the heading for order of 41/11 also. On 8, if possible, on 8 law. Because they have levied the execution case.
आपका एग्जीक्यूशन चल रहा है? क्या स्टेज में आपका एग्जीक्यूशन? आप ये कौन है जो एग्जीक्यूशन करा रहे हैं? Is it a landlord tenant?
हम इसको डिनाई कर रहे हैं।
आप कौन टेनेंट?
शुरू में पेरेंट है लेकिन एग्रीमेंट तो शेयर हो गया हम दोनों के बीच में 2,80,000 2,00,000 सब सबमिट किए उसके बाद सब पेमेंट देना बंद कर दिया। There is no
Is there any stipulation in the agreement that you will not pay rent?
कुछ नहीं
नहीं
Is there any stipulation in the agreement that you will not pay rent?
I will have to see that.
वो एग्रीमेंट लेकर आए।
मुझे हम फर्स्ट अपील का सर्टिफाइड कॉपी लेके आए। इन्होंने जो है ना स्पेसिफिक पर्पस ऑफ कॉन्ट्रैक्ट का केस किया था जो टाइटल सूट ये हार चुके हैं ताकि फर्स्ट अपील भी हार जी मेरे पास सर्टिफाइड कॉपी है जिसको देख लिया
नहीं है सुन ले
कल सुन अब तो सुनिए
इसको परसों की सुन ले कर दिया
आप बाहर से
नहीं रांची के
आप रांची के हैं आप रांची के हैं
जी हम रांची के जो लेकिन इनको लेके आने में बहुत दिक्कत हो जाती है
नहीं इनको लेके आने की क्या जरूरत है आप खुद ही वकील हैं
तो हम जरूर लेके आते हैं
ऐसे नहीं कर सकते ना भाई एक दिन तो उनको भी समय देंगे ना पढ़ने के लिए ठीक है लेकिन एग्रीमेंट लेकर आइए एग्रीमेंट में अगर स्टिपुलेशन नहीं है कि आप रेंट नहीं दीजिए तब बहुत मुश्किल है
एग्रीमेंट इनका 13/11/97 का था 6 साल के बाद में ये लीगल नोटिस भेजा शुड बी फाइल आफ्टर 6
स्पेसिफिक परफॉर्मेंस तो आप हार गए ना
उसके चैलेंज
हार गए ना
फर्स्ट
बस
अपील
आप उसको चैलेंज नहीं किए
फर्स्ट अपील भी हार गए जो मेरे पास सर्टिफाइड कॉपी
Serial number
The
25.
counsel for the appellant has submitted that the execution proceeding is going on. The appellant is the tenant.
Yes.
At his request, the matter is posted day after tomorrow at 2:15 to be taken up as first case.
Item
He has
number
undertaken to produce a copy of the agreement,
Yes, sir.
which is a bone of contention between the parties. Which is exhibit number?
Exhibit D.
item number 25.
Thank you.
In this case, there is stay till the next listing date of the appeal, and today it has not been taken.
सुबह 10:30 बजे से क्या करते हैं आप?
हम लोग तो रिस्पोंडेंट हैं।
आप respondent हैं?
हम अपीलेंट हैं और रिस्पोंडेंट की
तो
तरफ
अगर आप मेंशन करते हैं तो आप रिस्पोंडेंट की तरफ से कौन है? तो आप उनको नहीं लेकर आए।
फिर उनका पिटीशन स्टे वैकेट करने का
स्टे वैकेट करने के लिए पिटीशन दी।
रिकॉर्ड आ गया है।
लैमिनेटेड केस है
एक रिकॉर्ड आ गया होगा ना?
हाँ आ गया।
अब तो बस फाइनल हियरिंग सकते हैं।
सीरियल नंबर 26
Are not taken up made up.
फिर
कुछ नहीं होगा।
till the
अगला
next
भी काटा है।
date
tomorrow
there is
tomorrow कर दिया जाए सीरियल नंबर 26 उसमें एडिशन ऑफ पार्टी है सीएमपी एडिशन ऑफ पार्टी
इतना आसान नहीं है सेकंड अपील में आपका एडिशन ऑफ पार्टी।
ना इसमें सीएमपी सीएमपी
कोई बात नहीं। कभी नहीं हो सकता। आपका क्या करना है?
कल रख दिया जाए
अच्छा ये का केस करना। आज ही के दिन तक है स्टे।
हाँ till next date of the listing है।
अगला डेट में उठते समय हम एक्सटेंड नहीं करेंगे स्टे। आप जब मेंशन करिएगा आगे से हम इस तरह से स्टे एक्सटेंड नहीं करते
ठीक।
क्योंकि इतना सारा मैटर्स होता है टेकअप तो नहीं हो सकता ना। ऐसे नंबर 205 और 2023 The learned counsel for the appellant has submitted that the interim order dated 18/12/24 is expiring today. Landlord tenant है
नहीं ये टाइटल
and the matter the court could not reach the same case. Case for extension of interim order. Post this case on 12th of November. The interim order dated 18/12/24 is extended till 12th of November. 12 नवंबर बहुत लंबा हो जाएगा.
इसमें लॉकसी पर स्टाफ बैठक के लिए हम आईडी फाइल किए थे. इसमें गौतम कुमार हैं.
देखिए अभी चेकअप नहीं हो पाया ना. आप लोग भी तो सुबह मेंशन नहीं करते.
इसको गाइडलाइन जैसे इसमें
कब करना है बताइए. रिकॉर्ड आ गया, आप सुनेंगे इसको. अब कुछ नहीं करना.
जब भी रख दिया जाएगा.
बताइए, आप बता दीजिए कब करना चाहिए. आप बताइए.
नेक्स्ट वीक पर रख दिया जाएगा.
ठीक है, नेक्स्ट वीक.
इसको एक्सटेंशन नहीं किया जा सकता.
एक्सटेंशन तो करना पड़ेगा ना. टेकअप नहीं हुआ, आपने सुबह मेंशन नहीं किया. तो
मेंशन तो पिटिशनर साइड से करना था लोग से.
क्या चीज का? आप भी तो स्टे वेकेटिंग के लिए मेंशन
उनका आईएफ भाई है, हमारा भाई है.
15 तारीख को सुनते हैं. 15
उसी चीज के लिए हम दिए थे. आइए
स्टे वेकेटिंग नहीं होगा, फाइनल हियरिंग होगा. और फाइनल सुनेंगे. अब रिकॉर्ड आ गया ना.
इसको एक्सटेंशन किया जा रहा है लोग से. इसको तो
इसीलिए एक्सटेंशन किया जा रहा है 1 हफ्ता.
कि हम लोगों कोर्ट से ऑर्डर था कि इसमें लिस्ट ऑन जैसे जब भी लिस्टिंग होगा.
जब भी लिस्टिंग होगा, देखिए 100 केस रोज लिस्टिंग.
हाँ, उसी दिन इनका स्वतः जैसा समाप्त हो जाएगा.
हाँ, तो वो कहना समाप्त, इसीलिए
स्टे इनका समाप्त हो जाएगा तो फिर एक्सटेंशन हो जाएगा.
नहीं, 1 हफ्ता के लिए
हम
हम तो लिख रहे हैं कि हम टेकअप नहीं करते. मेरा गलती. आप लोग जब नहीं रहते हैं तो हम लोग टाइम पासओवर देते हैं कि नहीं. आज हम पासओवर मांग रहे हैं आपसे. समझ आ रही बात? पासओवर फ्रॉम माय एंड बिकॉज आई कुड नॉट रीच. ठीक है, 15 तारीख को बोलते ना. 15 बोलिए.
15 तारीख को
आप जो डेट चूज करिए. बताइए कौन सी तारीख को. दिवाली के पहले करना है कि दिवाली के बाद करना है?
दीपावली के पहले ही कर लेते हैं.
तो बाद ही कर लेते हैं. उसी में तुम डेट फिक्स कर देते हैं 11 तारीख को. On 11th of November 2025, the interim order dated such and such is extended till 11th of November. Liberty to mention. Liberty to mention. ठीक है? आप लोग दोनों मेंशन करेंगे, हम कैसे करेंगे? एक दिन पहले भी स्लिप दे देंगे करना है. ठीक है?